everyone. Welcome to the Environmental Law Institute's first webinar-only session of Summer School 2025, NEPA, ESA, and the Fundamentals of Environmental Law. I'm Madison Calhoun, Senior Manager of Educational Programs here at the Environmental Law Institute. We're so excited to see you here today. If you are not familiar with our summer school series, it is a series that ELI holds each summer, offering an introduction to the legal and policy foundations of environmental protection in the United States. We will have 4 hybrid sessions this year taking place every other week in ELI's office. We already had one of those in person last week, and we'll have another session next week at our office and streamed virtually about the Clean Air Act. There are also 4 online sessions this year taking place every other week, starting with this session. So we're so excited to see all of you online. The series is completely free and open to the public, and all sessions will be recorded and uploaded to ELI's YouTube page for the public to watch later. So if you can't make it to all of today's session, or if you miss any other sessions with summer school, be sure to check out our YouTube page. I'll now give just a couple of quick logistics about this program before getting started. So we will be saving time at the end for questions from the audience. So be sure to submit those anytime that you would like using Zoom's Q&A feature. The chat is also open. You're welcome to post any observations you would like throughout the program in the chat, but if you have a question that you would like our speakers to address, be sure to put those in the Q&A box rather than the chat. And then, as I said before, the session will be uploaded to ELI's website and YouTube page within a few days, so if you miss any parts, be sure to watch it back later. That is all from me, so I'll now hand things over to our wonderful moderator today. Jameson Colburn is the Joseph H. Goldstein Faculty Scholar and a Professor of Law at Penn State Dickinson Law. He's a leading scholar of environmental and natural resources law. He has published over 30 articles and book chapters focusing on the law of environmental assessment, habitat and at-risk species protections, and the jurisdiction of water disputes. His published work routinely considers the legal system's use of science and scientific information. Prior to teaching, he served as Assistant Regional Counsel at the U.S. Environmental Protection Agency and as trustee of the Connecticut River Watershed Council. So I'll hand things over to you. Thank you all so much for being here today.
Thank you. Good to be with you. We live in interesting times, as the proverb goes. I think we're living through 2 things, a new normal and what I would call a new abnormal. I think we're all familiar with the new normal, ping-ponging back and forth between the parties in power, driving administrative change in U.S. environmental law at a frenetic pace. The new abnormal that I would describe, though, is a growing chorus of criticism and calls for major changes to bedrock environmental laws in the United States, like NEPA and the Endangered Species Act. So we're very fortunate to be joined by 3 of the nation's best to help guide us on a tour of these 2 laws and what we can expect in the months and years ahead. Jonas Reagan is a senior associate with one of our premier environmental practices nationally, Beveridge and Diamond's Washington, D.C. office. His practice focuses on natural resources and project development, particularly concerning NEPA, the Endangered Species Act, and wetlands compliance. Mary Hollingsworth is the director of Harvard's Animal Law and Policy Clinic. Prior to joining the Harvard faculty, she served as a senior trial attorney in the Wildlife and Marine Resources section of DOJ's Environment and Natural Resources Division. For over a decade, she litigated cases arising under the Endangered Species Act in federal courts around the country. She also led the Department's civil enforcement of federal animal welfare statutes in cases like United States versus Lowe and United States versus Envigo. While at the department, she received the John Marshall Award from the Attorney General of the United States twice for her animal welfare work. Charmaine Morrison is a senior associate attorney with Earthjustice's Biodiversity Defense Program, which engages in national litigation to confront the major drivers of biodiversity loss. In this role, she's worked to protect manatees in Florida's Indian River Lagoon, the golden cheek warbler in Texas Hill Country, and insect pollinators nationwide. Charmaine received her JD from NYU, where she was a Root Tilden Kern public interest scholar and an editor of the NYU Law Review. She received her BA in sociology from UC Berkeley. Off camera, we decided that Jonas would go first with NEPA, so I'll hand it over to you, Jonas.
Well, thank you very much for that introduction, and what an esteemed panel we have. I'm feeling a little uncredentialed at the moment. I need to get some more alphabet soup at the end of my name. Well, thank you so much to ELI and Jameson. Thank you for the introduction. I know all of you have had that the environmental career panel, and so I'm just going to touch on one of the main statutes that you can make a entire career out of. ESA is one of the other ones. There's lots of other statutes that you can kind of focus on, but these are bedrock environmental statutes. So I'll get right into it. My presentation focuses on NEPA. Now, my intent for coming out of this presentation is that folks are going to understand the bare bones of the mechanics of NEPA, kind of the common pitfalls or challenges, and where NEPA is going to be going here in the next coming years, and what it's been going through as of late. All right. So just a little bit of context from why we have NEPA in the first place. It was passed back when bipartisan consensus was somewhat the norm around environmental regulations, and it was passed in 1969, signed into law January of 1970 by none other than Richard Nixon. And it's kind of heralded as the Magna Carta of environmental law, and potentially a misnomer that it's the first major environmental law. There was one that preceded it on interstate environmental requirements, but we can save that discussion for a happy hour or something after a seminar one of these days. All right. So kind of the context behind what led up to NEPA. There were so many major environmental issues and kind of disasters in the late 1960s and earlier that kind of influenced national policy on this issue. So you had the 1969 massive oil spill in Santa Barbara, California. That's what this image is of. There were several fires. So there was one prominent fire that everyone's probably very familiar with from any kind of environmental law course or environmental studies curriculum, the fire in the Cuyahoga River. There's massive smog pollution issues, New York, Los Angeles, other major cities, Boulder, Colorado, other areas. And there was the expansion of the interstate road system. And all of these kind of led to there was also the publication of Silent Spring by Rachel Carson and other folks that encouraged this movement. So for those who kind of weren't alive at the time, as I for sure wasn't, going back for just what the Cuyahoga River was actually like back in the day. I mean, it was these are direct quotes, and this kind of stood out to us as we were preparing this presentation, which was no visible life, some river. That's not really what you want to hear for the Cuyahoga River. There's some rivers, chocolate brown, oily, bubbling with subsurface gases, oozes rather than flows. Personally, I would like to have some distinction between molasses and a water body, but this was the case. This was the current state of play within the United States at the time. So all of this kind of led for more environmental regulation and a push for agencies to consider and incorporate environmental impacts into their everyday decision making. There comes the National Environmental Policy Act, right? So what is NEPA? NEPA requires all federal agencies to consider the environmental effects of their actions. It was kind of a death by 1,000 cuts kind of situation in the 1960s, where if you weren't being active in your analysis of the potential environmental effects, it was very easy for things to compound and have a cumulative negative effect on the environment that was otherwise unintended by the federal action. And so one of the main things the NEPA does is it requires all federal agencies to consider or as all NEPA practitioners know, and everyone who took an environmental law course knows, take a hard look. That is the language that comes from the case law, that you have to take a hard look at the environmental effects of your action. So NEPA had and still largely has, a heavy emphasis on public participation. So this is consider the environmental effects, publish those, make those known to the public, so folks know what is a potential impact of having this project in their area, in their neighborhood, even next door, right? So NEPA also established the Council on Environmental Quality, or CEQ, as I'll refer to it throughout the presentation. This is a agency that recently kind of went through some changes that I'll discuss a little further on in the presentation. But CEQ is kind of tasked with almost a consulting role of an agency that can opine on NEPA compliance, can propose guidance and other ways to help other federal agencies comply with NEPA. Now, this last point is one of maybe the hardest points for folks getting into NEPA practice, as you know, from what I've run into, which is that NEPA does not mandate any particular result. You can read these environmental analyses, and the agency can go through some alternatives, and there can be less environmentally impacting alternatives considered in these documents. But there is no requirement in NEPA for the agency to pick the least environmentally impactful alternative. Oh, it's just to consider all of the potential effects. So the agencies can still decide to go with the more environmentally impactful alternative. It's just to create that informed decision-making at that agency level. So this is illustrative quote from Department of Transportation v. Public Citizen. This was heavily cited in the recent Supreme Court decision, which we'll talk about a little bit later. But this really sums it up quite nicely. Just NEPA's purpose is not to generate paperwork, even excellent paperwork, and I've had my fair share in drafting one of those, so I'll let you decide which one's which, but to foster excellent action. And so the agencies just need to be aware and understand the potential implications of the choice that they will eventually make. So where all good analysis starts, is it covered under the statute? What does NEPA cover? NEPA is limited to major federal actions, and we'll get into all of these aspects. Major federal actions significantly affecting the quality of the human environment. And so just keep this in mind. We'll dive into this a little bit. So major federal action, an action that the agency carries out a discretionary responsibility. There's been some movement through legislation or other executive orders and kind of pushes through that way to try to limit what major federal action means, which would limit the scope of NEPA. Maybe there's a funding threshold. Maybe there's a footprint threshold. Maybe there's something along those lines. But major federal action did not mean to apply to every federal action. Otherwise, Congress wouldn't have put major in the statute. And we all know that congressional intent is key in these analyses. So significantly affecting. This is a fact-based analysis of what can significantly affect the human environment. So while CEQ regulations are going through this kind of midlife crisis, if you will, it's still they're still going to evaluate the significance based on context, intensity, duration, these kinds of aspects of the environmental effects of the proposed action. Now, in practice, for all the agency folks out there or folks trying to get a permit or anything like that, I would err on the side of caution, because you don't want to be caught flat-footed with a failure to comply with NEPA. In practice, unless specifically exempted by a statute or a rule, NEPA applies to discretionary federal action. This could be approving funding, assisting or conducting plans, projects, programs, issuing permits, lots of these kinds of activities that can trigger a NEPA analysis. So, all right. So before I get into the fundamental building blocks of NEPA, right? We've covered what it covers, major federal actions significantly affecting the human environment, and kind of touched on what those kinds of what that means in practice. But here's before we go on into the specifics, there is some recent activity that may color some of the future discussion. So recently, consistent with President Trump's executive order unleashing American energy, the Center on Environmental Quality, they issued an interim final rule which rescinded its NEPA regulations that implement the statute, right? And that was effective about a couple of months ago. So CEQ does not have these regulations at the moment. However, CEQ did publish a memorandum stating that those regulations that were recently rescinded still carry persuasive authority while the agency now develops guidance, and each of the other agencies will be developing their own respective NEPA regulations over the next year or so. The memorandum gave the agencies a 12-month window. Whether or not they will stick to that window has yet to be seen. It's a very complicated process that requires coordination across a lot of levels of the federal bureaucracy here. So while we are without the guiding star, so to speak, NEPA implementation may vary by agency and evolve as agencies revise their own regulations, and maybe there's going to be other executive orders or CEQ memoranda that would influence or affect the context of what I'm about to present on. However, what I'm going into today is the state of play as of today. So just bear with me and have that context in mind. So this is the general flow chart for major federal actions that may significantly affect the human environment here, right? So, and I'll go into what each of these mean. So you have categorical exclusions, you have environmental assessments, you have environmental impact statements, you have FONSIs, mitigated FONSIs, RODs, lots of alphabet soup. You wouldn't be talking about environmental law without a lot of letters and acronyms here. So I'll go into what each of these means here in a little bit. So for categorical exclusion, right? The most common, and I'll reiterate this later as well, the most common mistake that I've seen in practice is equating a categorical exclusion to an exemption from NEPA. The categorical exclusion is actually a substitute for the NEPA analysis, right? So that is for projects that need NEPA. You cannot just say, I fit within a categorical exclusion, therefore I don't have to comply with NEPA at all, right? So this is part of the process. each agency can identify kind of routine actions or actions that they frequently encounter, or ones that they just want to publish a CADX for, right? These are actions that typically do not have a significant impact. And this will go through your notice and comment, Federal Register. There's going to be a consultation with CEQ. Whether or not that's as instrumental as it was in the past is yet to be seen. I would err on the side of it's going to be kind of an informal consult. CEQ probably won't have yay or nay authority. And then if your activity, if your project fits within the identified categorical exclusion, then that is your NEPA analysis, because it's oftentimes there's maybe conditions or other things imposed on the project through that analysis, and you would voluntarily comply with those. But that means no environmental assessment or an environmental impact statement is required for actions that fit within that CADX. You can also, under the recent change in the Fiscal Responsibility Act, agencies can now also adopt other agencies' categorical exclusions. So before, you had to go through the exact same notice and comment, propose the things for things that have already been proven to not have a significant effect. But that is one kind of streamlining change as recent as 2023. So these are broad strokes. Typically what most agencies include as a CADX. This could be administrative functions, O&M activities, research collection, maybe emergency preparedness, or other minor land management or infrastructure activities, right? These would have to be deemed not significant impacts in order to kind of be allowed to be a CADX and fall within those kinds of parameters. And it's a cost saving measure. It's an agency resource. There are limited agency resources, even more now than before. And this reduces a lot of the paperwork and saves agencies some time in proceeding on evaluating certain projects, right? But like I said earlier, it is not an exemption from NEPA. Despite its kind of name, it's a little misleading, but it's a categorical exclusion, which is itself a subset of this NEPA analysis. It's kind of, you're going in the steps of other projects before you. So I want to give some examples of this. Here's a Department of Energy example of a categorical exclusion. The site office wanted to move some materials from one lab to another, right? Within this photo, right? They just wanted to transfer that. It is a discretionary federal action. There could be some effects here. So without the prior analysis, they might have had to go through the EA process to arrive at no significant impacts. But because the Department of Energy had this categorical exclusion, which is transfer actions in which the predominant activity is transportation, which was this, they did not have to go through the rigmarole of conducting a separate project-specific environmental document. So now that's categorical exclusions, right? For other activities, I want to turn now to this isn't, if you didn't catch the alphabet soup there, this is the environmental assessment part, the EA process. Now I've put at the first bit scoping. This is a recent change, but it used to be kind of discretionary anyway. I've seen it kind of both ways, where agencies may, depending on how complicated or how controversial the project may be, they may start with a scoping process for projects that have an environmental assessment. For EISs. It is absolutely required, and we'll get there. We'll get there later. So there will be an initial, either it's done internally or with the project proponent, of kind of what are the environmental effects. There will be a draft environmental assessment. They may publish that for public comment. It is discretionary. If folks, if it's a fairly contentious project, they would, in the past, agencies have leaned towards more public involvement and more public engagement to try to synthesize all of the potential environmental impacts of the project and kind of get ahead of any of that criticism, so they don't find out in a subsequent lawsuit. Now, if there's no significant impacts identified, there may be a preliminary FONSI, and then a final FONSI, and we'll get into each of these processes here. So generally, when you're identifying all of the environmental impacts of your project, it's good to look at what an EA is and what needs to be included in there, right? So the text of the statute, a concise public document setting forth the basis for an agency's FONSI, finding of no significant impact, or a determination that there may be significant environmental impacts triggering the environmental impact statement process, right? So that's kind of the guidance that folks have to go off. Now, typically, and this is, it's going to include the purpose and need. What is the purpose of the project? What is the need of the project? Why are we doing this? The alternatives to the project analyzed. This can include a no action alternative. It could include the project as proposed. It could include variations that have certain mitigation components, right? The environmental impacts of those actions and alternatives, and includes the folks kind of consulted in the process to make sure that there's public participation, especially if there's impacts to tribal lands or other sensitive resources. It's good to have that interaction documented. Now, what it does not cover, and I'll caveat the second one here in a little bit. So up until this year, EAs were required to include environmental justice impacts. These are, sensitive communities, historically disenfranchised communities. It could be income, it could be racial, it could be ethnic, it could be a lot of other factors that can identify what makes an environmental justice community, right? There were tools available at the federal agency level in that. But under the most recent guidance from CEQ, they direct all agencies to not include environmental justice within their environmental assessments or within their environmental impact statements, unless required by statute, some other statute. So there's we'll get into this a little bit later. There's state NEPAs. They're called little NEPAs. Sometimes those will require environmental justice impacts, or other agencies will require environmental justice impacts to be considered within their environmental documents. Now, on the climate change front, folks might have, this goes back to the ping-ponging that Jameson talked about, the collective whiplash that we're all having. Under the Biden administration, there was an EO that explicitly required the inclusion of climate change within the environmental assessment and within the environmental impact statement. And now President Trump has rescinded that executive order. Now, that doesn't necessarily change what you're required to include in the document, because courts have consistently held that climate change should be included as part of a cumulative impacts analysis on any of those projects. Now, whether or not that's tweaked based off the recent Supreme Court decision that limits effects to the project, that's yet to be seen. So I just wanted to flag that for as one of the many developing areas of NEPA practice. Now this applies to EAs and EISs and a little bit to categorical exclusions, which I'll touch on here in a sec. Charmaine and Mary are going to touch on a lot more of the ESA aspects of practice, but there is some intersection, so I wanted to just tee this up. As part of agencies' environmental analysis, species impacts are, they have to be included in those requirements. So there is some intersection. If your project is going to affect listed or protected species or designated critical habitat, that's something that should be analyzed within your environmental documents. These are separate requirements. Including them within your EA or your EIS does not satisfy your Endangered Species Act obligations or vice versa, right? So NEPA does require effects to listed species, and oftentimes impacts to listed species are one of the triggers for kicking a project out of a CADX. So if you would otherwise qualify for a categorical exclusion, but there's species impacts, you should very carefully consider relying on that categorical exclusion, because those impacts to species may make you no longer eligible. So that is all I will highlight here. I could maybe put plant a seed for future discussion, which is now that agencies have more discretion under NEPA, there may be situations where the NEPA document is upheld, which relies on a biological opinion evaluation of species impacts. And maybe there would be some interplay or some conflict if that biological opinion was invalidated down the road. Just some food for thought there. But I don't want to get ahead of myself and eat into Charmaine and Mary's forthcoming presentation. So after including all of these impacts, they're going to conclude one way or the other, right? Are the impacts not significant, in which case agencies will issue a finding of no significant impact. There's a small caveat for the practitioners out there, which is project proponents may voluntarily advance mitigation measures that keep the project below that significance threshold. If the agency comes back and says, it's on the fence, we're going to go with probably significant impacts, then you can kind of have some creative back and forth on how to get the impacts back down below that level of significance. And so that can be called a mitigated FONSI, right? Now, the other option is the EA can conclude that there are significant impacts, and that kicks you squarely in the EIS camp, which is a much more rigorous assessment, a detailed statement evaluating the action's environmental effects. And we'll kind of get into the timing differences and everything like that here in a bit. And I need to pick up the pace. So here's one examples of an EA that kind of led to a FONSI here. This was EPA was evaluating construction for a municipal compost facility. It's just a 23-page document, not this elaborate environmental analysis for something that would maybe trigger an EIS. The two alternatives were, the action or no action, and it was on an existing gravel pit. The site was mostly bare. It already had the access roads. There was no kind of development, and the other landfill was at capacity, which would have other significant environmental impacts in the no action alternative scenario, right? So this is just, I just wanted to give folks an idea of what things can be not significant impacts. So this one was greenlit under a FONSI in February of last year. This is another situation where there was a, they wanted to condemn the small building. If you, maybe you'll have to zoom in here on your screens at home, but there was the blue, I guess you would call that a rectangle. I'm not a mathematician here, but that was the building that they wanted to condemn and rebuild. In the same place, there was a potential impact to cultural resources and maybe 8 to 10 trees, but the Native American band's tribal historic preservation officer said that there would be no adverse impacts to those culturally sensitive resources if they're, the use of a chain link fence and all of that. So this was a situation which led to a FONSI because the chain link fence was put into the project. Potentially this was a mitigated FONSI, but I have to kind of dig deeper into the analysis there, but you can see the scope of the impact here. Now this one was kicked over into the EIS camp, right? And so this is one of the situations, you'll find this a lot in case law, and I will kind of go back and talk about typical challenges here in a little bit, but this is one of them, right? So here, the Army Corps of Engineers, that's US ACE, issued a permit for a wetlands fill. So it's a 404 permit under the Clean Water Act. I'm sure everyone already is familiar with 404, and if not, you will be by the end of this summer series. So the Corps issued a environmental assessment and the finding of no significant impact just based off of the project area, right? Now the court here determined that, court and Corps. The court, I'll enunciate better. The court determined that the Corps acted arbitrarily and capriciously in considering only the project footprint as opposed to the project area. So they remanded it back to the agency to do a environmental impact statement consistent with NEPA. So this case decided in 2005. If the same case was brought today, maybe the Corps would be given more discretion under the recent Supreme Court decision, but this is just, again, an example, not something to kind of hang your hat on, right? Always keep up to date with the other changes. So now I'm gonna start going into the EIS process, right? EISs, environmental impact statements, must start with a notice of intent in the Federal Register. So this is a publication of, hey, this is what the project is going to be, alerting folks to provide feedback and allow agencies to start engaging in the local communities. There's going to be a draft EIS that is published for public comment, and then there's a final EIS, and then there's once that is approved, the agency will issue a record of decision. There is no final agency action until the record of decision is issued. So for those wanting to challenge NEPA documents, it's very important to not do so prematurely, because final agency action, this is a whole separate soapbox, but you have to wait for final agency action in order to challenge any decision of the APA. So wait for that rod. So this is scoping. This is the notice of intent. So notice of intent will typically include description of the project and any kind of meetings or scoping process that the agency will engage in. These can include, there's public meetings, there can town halls, there's public comment opportunities. You could even have, formal hearings on some of these projects, but there should be opportunities for the public to be engaged and to make comments and provide additional information on potential project impacts. That will all go into an EIS, which is a detailed statement that includes reasonably foreseeable environmental effects of the proposed agency action, a reasonable range of alternatives, and the no action alternative analysis, right? So this is a lot more detailed and a lot more involved than an EA. So just something to be aware of the fundamentals there. I want to give some examples of projects that would trigger kind of this more in-depth analysis, right? So this was construction operation of a new federal courthouse. There were lots of other kind of impacts included, short-term air quality impacts from construction. There was traffic impacts. You're adding in a new significantly trafficked building in a different area. Like you can see the, or maybe that's a little too small, I apologize. There's the yellow shaded for the Woodland site and the Allen site and I guess that would be fuchsia. And the analysis went back and analyzed impacts at both of those different locations. So either one is going to increase traffic in that area and may have some other impacts in the local communities. So this was one that did not fall within the lower threshold of an EA, but this triggered an EIS in this situation. Other ones are these kinds of large issues. So this is the grizzly bear restoration plan. This covered the entire Northern Cascades ecosystem in Washington and would have a potential significant effect on the human environment. And so this was, this was a plan for the management of this whole resource system. So that was one that also triggered an EIS. These are ones that can have major environmental implication. And so that's what needs to go in there. This is where I could go through a lot of other examples of EISs, but just to give folks an idea of the key differences between EAs and EISs. This chart is incredibly illustrative of this discrepancy. Now, most of the projects are categorical exclusions or EAs. Right? It's the far and few between trigger these more involved analysis under an EIS. And so with here, you'll see that as opposed to that 28-page EA or some of these other more niche and limited analysis, EIS is typically around 600 to 700 pages. Whether or not that's inclusive of appendices, that's not been my experience. The appendices typically kick it a little higher. And so this is just text of the analyses of the environmental impacts of the proposed project. It can also take a significant amount of time, over the past, 15 years or so. They hover around 2 to 3 years from your notice of intent in the Federal Register to the final EIS, right? There's some developments a couple years ago in the FRA. There's now limitations to an EA, so no more than 75 pages. So this gets you kind of the ballpark and limits it to about 1 year. EISs are limited to 150 pages, not including citations or the appendices. So you may see a lot of folks moving that analysis into an appendix. And it limits the EIS timeline to 2 years. Now, something to be aware of here is if the agencies hold themselves to this rigid timeline, and if project proponents hold the agencies to that rigid timeline, they may be left with a very difficult environmental document to defend. So, like with some of the ESA timelines for buyouts. I'm not going to spoil it, but there can be some voluntary agreement between project proponents and the agencies on extending that deadline just to make sure you have the most defensible document possible for your project. Kind of jumping around a little bit, but I am running low on time. Just so folks are aware, you can have programmatic NEPA reviews if there's kind of an overarching activity in an area. They can also be tiered. So it can say all of this is not significant, but if you're doing X, Y, and Z, you'll have to go through a more rigorous analysis on those aspects of the project. So it can be a little bit of a tiered review process there. So just something to be aware of. Now, everyone wants to know about typical NEPA challenges. This is kind of where the rubber hits the road, right? So the typical ones are the agency didn't consider something, right? As you know, maybe there's traffic impacts or something else, like the original lawsuit in the recent Supreme Court case, where it was, challengers asserted that the analysis failed to consider upstream and downstream impacts from the railroad construction, right? So that's a failure to include something or adequately consider that within the NEPA document, or they ignored a reasonable range of alternatives, or they issued the wrong level of analysis. So they did an EA and a FONSI, but they're saying, oh, these are clearly significant impacts and should have triggered an EIS. So those are some of the major NEPA challenges. Now, the logistics of a NEPA challenge are there is no citizen supervision here. So what do? Well, you go back to the Administrative Procedure Act, right? These are going to be challenges for arbitrary and capricious, final agency actions that are arbitrary and capricious or otherwise not in accordance with law. And folks can challenge the NEPA compliance under the APA. Now, it's important for NEPA practitioners on all sides to be aware of the implications and the potential consequences of failing to comply with NEPA or facing a NEPA challenge. Your project can be enjoined. You can be kicked back to the drawing board. It can be remanded back to the agency, and your project cannot make forward progress until you complete an adequate NEPA analysis. It can require supplementation of the analysis, which your project will usually be stayed while you are combining and collecting all of that additional information. And above all, from my experience, is delay, right? So from the project proponent side, there's lots of behind the scenes actions that make projects happen, and delay can often kill large infrastructure projects or can seed doubt in some of the other agencies and delay their issuance of permits until the NEPA analysis is complete. So these are all very practical consequences for your activity. Now, these are similar on the agency side. If the agencies failed to go through a NEPA analysis, then these can also affect the agency. So something to be aware of from all angles of the practitioner side. So here I want to talk a little bit about the state equivalents. There can be some we call little NEPAs or state environmental policy acts, SEPAs. Currently, there's 16 states that have them. There's there's New York City has one as well. So you can have like local equivalents, and I believe there's one out in Tahoe as well, a Tahoe regional environmental Policy Act. But District of Columbia and Puerto Rico also have these requirements. So these are focused on state actions rather than major federal actions, and they can, as per most federal statutes, they are the floor. So these state NEPAs can differ in very significant ways, such as, the California Environmental Policy Act, or CEQA, as it's affectionately called. Mandates agencies require all feasible mitigation measures for significant impacts. So that is a somewhat substantive requirement that you have to have in that NEPA, in that CEQA analysis. That is a sharp deviation from general NEPA practice, which is a purely procedural statute. So some of these state requirements can include or mandate effects of specific consequences, like greenhouse gas emissions or environmental justice, as I referenced before in CEQ's memorandum. Unless otherwise required by law, this could be the other law that requires it. So just some other differences between those, just taking CEQA as an example, while under NEPA, they have CADXs, California has categorical exemptions, right? Instead of an environmental assessment, there's an initial study. Instead of a FONSI, there's a negative declaration. Instead of an EIS, it's an environmental impact report, right? Using the same terminology would just be too easy. Let's switch it up and add some more letters in there. Now, I want to touch on very briefly recent court decisions. So there were a couple of federal district courts that over the past year that declared that CEQ does not have the authority to issue binding regulations. This is why we are seeing the CEQ rescind those regulations, and now they're going to provide kind of guidance to the other agencies on how best to comply with NEPA, right? So right now, CEQ does not have that binding regulatory authority, and that goes back to a kind of a textualist interpretation of the statute, which just basically says, they can oversee NEPA and guide compliance, but there was no actual requirements, regulatory authority given to CEQ. Now, the main one that most people are talking about recently is the 7-county infrastructure coalition versus Eagle County, Colorado. This was a recent Supreme Court decision on NEPA. I will note for the record that the federal government has yet to lose a NEPA case at the Supreme Court, and this keeps that shutout history current. Right, this was an 8-0 decision. I believe it was Justice Gorsuch who recused himself, as there may have been some relation to the railroad that was being built. But this is an 8-0 decision, right? So we do have bipartisanship on this issue. Not that it's partisan. The decision stresses substantial judicial deference required in NEPA cases. So this is a kind of, again, a whiplash from the overturning of Chevron deference. Here, it's a fact-intensive inquiry, and the court emphasized that the agency is in the best position to determine what factors would make it a significant environmental effect that's under the purview of that agency. And so there was a lot of deference required now in NEPA reviews, right? They held that the action agency did not have to consider those upstream and downstream effects. This is what may kind of impact those climate change, that cumulative effects kind of analysis in an EIS, because those effects were separate in time and place. And who knows how that's going to play out with the more substantial deference owed to these environmental documents. Maybe the analyses will be shorter and kind of less comprehensive and extensive as they have been in the past. They also emphasize the strict procedural nature of NEPA, that there's no substantive requirements. Just very briefly, Something to be aware of is some other executive branch activity here. There's the President Trump's executive order, which kind of guided CEQ, which is squarely within the executive branch, to rescind those NEPA regulations. And CEQ has published kind of that interim final rule and is asking other agencies to develop implementing NEPA regulations here in the foreseeable future. So just something to be on the radar of all of this. But so we've covered what it covers, what it is, what the basic kind of mechanisms of NEPA are, and kind of the issues and cruxes and challenges. There's lots more with NEPA practice, but I do want to not take too much of my time. So with that, forgot about the technical. Just read these. They may or may not pass, but there are potential NEPA implications in there, or read the materials. I believe they'll be posted on the website after that. And with that, thank you very much. I will turn it over to Mary and Charmaine.
Thank you, Jonas. Please, Mary.
Great, thank you so much. So thank you again for inviting me here today to discuss one of the most important environmental statutes, the Endangered Species Act. Charmaine and I are going to walk through the key provisions of the ESA, the ones that are most likely to come up in litigation, including listing and critical habitat, Section 4, Section 7 on interagency consultation, take prohibitions on Section 9, and the exceptions in Section 10. So, but before we get to the ESA provisions, I would like to provide a little bit of context to the passage of the ESA. If you're new to the ESA, I think it's helpful to understand where we've been and where we may be going if we're not careful. So, taking us back to early in the 20th century, the passenger pigeon goes extinct. And the story goes that just a few decades earlier, there were so many passenger pigeons that when they would take flight, they were said to blacken the sky. There were like billions of them. And then there was this really dramatic decline of the species in a really short period of time that was in large part due to intensive hunting. And essentially, that was enough to prompt Congress to enact the first federal wildlife statute, which was the Lacey Act, which prohibited interstate commerce in illegally taken wildlife. But the passage of the Lacey Act didn't necessarily sort of slow the decline in populations for species. And so over the next few decades, you have several other bird species disappearing from the American landscape, with the extinction of the whooping crane appearing essentially imminent by the 1940s. So at this point, the Department of Interior begins to work on projects to prevent the extinction of seriously imperiled species like the whooping crane. And these efforts are formalized in the mid-60s with the creation of the Committee on Rare and Endangered Wildlife Species, which actually creates the first unofficial list of endangered species within the United States. And then afterward, there's the passage of the 1966 Endangered Species Preservation Act. Now that act focused exclusively on species native to the United States. Around the same time, there's some momentum growing internationally to address drastic declines in species, particularly due to, for species being commercially hunted and traded basically into extinction. And that leads to the Convention on International Trade in Endangered Species of Wildlife, Fauna, and Flora, which we refer to as CITES. And CITES restricts the trade in plant and animal species believed to be harmed by trade. And in the US, as of now, it is implemented by the Endangered Species Act. So these international efforts basically motivate Congress and once again the Nixon White House to kind of go back to the drawing board and strengthen existing law by adding some of the important provisions that we'll be discussing today, including Section 9. What's interesting about the passage of the ESA is, so at the time, so it passed with unanimous approval in the Senate and near unanimous approval in the House. And so that's the starting point for this really important statute. There we go. So in terms of what the purpose of the Endangered Species Act, so when I look at a statute, I always start with the congressional findings. And essentially what Congress says is we've had this sort of rampant economic growth and development without any consideration as to conservation of species. And that has depleted a number of populations. And I think what's interesting is, Congress goes on to say that these species, like, they have importance to us. It's beyond, just the scientific value or the recreational value. There's also aesthetic and ecological value, and it's important that we protect these species. So essentially, Congress says that we have to take steps to protect these species, and we're going to do so in two ways. One is to protect the ecosystems on which endangered and threatened species depend, and we're also going to conserve the species. We can debate about whether or not Congress actually provided the tools necessary to achieve those goals in the statute, but I think the goals are pretty clear. Conservation in the ESA context, it's defined, it's not just about keeping, a handful of individuals alive. It's not just about survival. Conservation means recovery of the species so that they don't actually need these protections. And so the steps that are built into the statute, which Charmaine and I are going to be discussing today, are identifying what species meet the definitions of endangered, threatened species. And then for those species, you designate critical habitat. They are protected through by and large, protected through Section 9 take. And then there's also a recovery planning process. So, as I mentioned, the ESA breezes through the House and the Senate. Nixon signs it into law. But just a few years later, the ESA lands in the Supreme Court. And I think a lot of people believe that's sort of the turning point of this, like, unanimous consent. And it didn't take very long to get there. But so essentially, there's this little fish called the snail darter, and it is listed as endangered. And it relies on this stretch of the Little Tennessee River, which is designated as critical habitat. So the problem, though, is that before the ESA is even signed into law, Congress has already identified this location for the construction of the Tellico Dam, and it's appropriated funds. The construction is essentially near complete when the Tennessee Valley Authority, which is a federally owned electric utility corporation, is sued for failure to comply with Section 7 of the ESA, which Charmaine will discuss in a moment. But the basic argument is, okay, you didn't really mean that we have to stop construction or just stop, not complete the construction of this dam for this little uncharismatic fish. And what the Supreme Court says is and I'll give you the quote, the plain intent of Congress in enacting this statute was to halt and reverse the trend towards species extinction, whatever the cost. This is reflected not only in the stated policies of the Act, but in literally every section of the statute. This is from the Supreme Court. So following this decision, Congress amends the ESA to create the God Squad, which is a committee that is composed of 7 cabinet-level members, and it has the authority to allow the extinction of a species by exempting a federal agency from Section 7 requirements under very specific circumstances. So, you know, Congress already sort of immediately is like, hold up, you know, we need to cabin this, we need to put some limitations here. So turning to what does the ESA protect? I would say for the most part, generally speaking, to be protected under the ESA, a species has to be listed as either endangered or threatened. And so the difference between endangered and threatened, as you can see in the definition, endangered is, you know, the species is currently in danger of extinction throughout all or a significant portion of its range. I'll pause there just for a moment. So significant portion of its range. If a species has, you know, a very important population, and that population is endangered and is determined to be significant, then the species will be listed range-wide. So there are 2 ways. Either range-wide, the species is determined to be in danger of extinction, or in the significant portion of its range, it's determined to be endangered. And then threatened species are those that are likely to become endangered within the foreseeable future throughout all or significant portion of its range. And I think it's interesting, in the years that I was sort of heavily litigating these cases, there were a lot of cases around what does the foreseeable future mean? How do you establish that? You know, what's the time frame? And I'll give you one example in a moment, but I think moving forward, I'm interested to see whether or not there actually will be more litigation on what's the point at which the species is in danger of extinction, because as you know, climate change and other impacts start to put more pressure and have more sort of real-time effects on species, we're sort of out of the threatened species, like we're out of that sort of zone, and the agencies are going to have to figure out, okay, what's the point at which we now actually have to uplist? And there aren't a lot of cases, though there is a recent one pending that discusses that. So before we talk about the listings themselves and the criteria, I want to say that so the ESA is actually administered by 2 agencies. So in the context, when you see secretary in the Endangered Species Act, it means both the Secretary of Interior and the Secretary of Commerce. The Secretary of Interior, it manages or administers the ESA via the U.S. Fish and Wildlife Service, and that agency manages the vast majority of the species that are listed. And then Secretary of Commerce is through the National Oceanic and Atmospheric Administration, NOAA. Fish and Wildlife Service generally handles terrestrial and freshwater species, and NOAA has responsibility for marine and anadromous species. So in terms of actually listing species, the statute directs these agencies to consider 5 factors, which are listed here. And in my experience, I think factor A now is the one that comes up most often, or at least comes up very frequently, which is the destruction, modification, or curtailment of habitat. So there are the ESA sets out very clear steps in terms of listing species. So, and a species can be listed in one of two ways, either by the Secretary's own initiative. And I would say this doesn't happen, it doesn't happen as frequently as by petition, but the agency is required to do status reviews of species. So in the course of doing a status review, for example, the agency could come to the conclusion that a species should be uplisted, which, for example, go threatened to endangered, or downlisted, endangered to threatened, or delisted, where they would be removed from the list altogether. So, but frequently these steps happen by petition, and any one of us on this training could submit a petition to either list, uplist, downlist, or delist a species. And so the first step, the agency gets this petition, and it has to look within like basically the four corners of the petition and then whatever is in their files to make a decision about whether or not the petition, would lead a reasonable person to conclude that, yes, whatever action is being requested, that it might, that there's reason to think that that action might be warranted. Now, we call it the 90-day finding, but very frequently it takes more than 90 days. The statute actually says like to the maximum extent practicable. So the agencies do have a little bit of wiggle room there. I do like to flag though, so if the 90-day finding is positive, they're like, yeah, there's enough information here to warrant additional review, that the next step is the 12-month finding. But the 12-month finding isn't 12 months from the 90-day finding. It's from the receipt of the petition. So if the agency takes 10 months to issue a 90-day finding, then in theory, the 12-month finding should be issued within 2 months. But guess what? Probably not going to happen. There's a ton of litigation that happens just around the timing of these steps. So if the 90-day finding, if they conclude, nope, not enough information here, the process is over and that negative 90-day finding can be challenged. If it's a positive 90-day finding, it goes to step 2. And at that stage, the service can consider all the information. They can go to other federal agencies, they can go to, scientists, academics at universities, anyone can submit information, and they consider all of that information and come to a conclusion at the 12-month stage. So the conclusion is either, yes, this action is warranted, or no, it's not warranted, or it's warranted but precluded. If it's warranted, then the next step is to go through the rulemaking process, at which point a proposed rule will be drafted and the public will have an opportunity to submit comments on it. So delisting follows a similar path. You can submit a petition to delist, as I mentioned. Delisting tends to happen either, if a species goes extinct, you like to hope that that doesn't happen very much anymore, but it does happen sometimes. So it can be delisted because they went extinct. It can be because they recovered, which also happens. And or it could be that based on new information, the species no longer meets the definition. So very briefly, I like to use the polar bear example. Polar bears are such a charismatic species. Who doesn't love polar bears? But the case is, in my view, really important because it's the first one in which the species is listed, essentially primarily based on effects due to climate change. And I think it was a bold move by the service that's in line with what was expected of this statute. So in 2008, the service issues a final rule listing the polar bear as a threatened species. And anytime the agency lists a species as threatened, they're going to get sued by everybody, right? And that's exactly what happens. Their fish is sued by a number of environmental organizations who that believe that the polar bear should be listed as endangered, and then on the other side by like Safari Club and Pacific Legal Foundation, State of Alaska, and others who do not believe that the polar bear should be listed at all. So what information the agency has in front of it is that, the polar bear, like 5 out of the 19 populations are declining. The polar bear, as we all know, are sea ice obligates. They are nutritionally stressed because they are dependent on other sea ice obligates, which are the seal species that depend on ice to live. And what they have is all this information, in particular from the International Panel on Climate Change, about the declines of sea ice and the likelihood that they're going to continue, that the sea ice is going to continue to decline over time through the end of the century. And really that the polar bears, there's no chance that this polar bear is going to be able to adapt that quickly. So as I mentioned, this foreseeable future discussion, it is foreseeable future isn't defined by statute. It is a species specific assessment, and it's a tricky one. So basically what the agency has to determine is, one, based on the threats to the species, how far out can we predict that that those threats are going to continue to be an issue? And then how far out can we predict the species' response to those threats? So the foreseeable future conversation happens in the context of both of those questions. And in the case of the polar bear, there are a lot of different projections about greenhouse gas emissions, but all of the projections are showing like basically they're unanimous in the sense that that the temperature is going to continue to warm and the amount of ice that is available is going to continue to be reduced. And in this case, the service, I think, took probably the most conservative approach that you could take in this scenario, which was to look out 40 to 50 years. Because the impacts of greenhouse gas emissions, there's a lag time between the emissions themselves and the impacts from those emissions. And so we already know what has happened in the last, you can look at modeling to see what the emissions have been, and there's this lag time. So they were able to say, okay, we already know for a fact what's going to happen in the next 40 to 50 years. And so they used that as the foreseeable future and concluded that the species should be listed as threatened. So again, I think it's one of the more, it's a very well-known foreseeable future analysis, and it's, essentially the first from a climate change perspective. But that same foreseeable future analysis is used in any case involving threatened species. So once a species is listed, there are several steps and protections that come into play. And the first one is, the designation of critical habitat, which is also under Section 4. So the agencies can designate either occupied or unoccupied habitat, and the determination is based on the point of listing. So if the area was occupied at the time of listing, even if the critical habitat isn't designated for another, 5-10 years for some reason, at that point the population has shifted, you would still base it off of the point at which the species was listed. So Usually the agency goes through, looks at the occupied habitat, makes a determination about whether that's sufficient, and then if it's necessary, they'll also look at unoccupied habitat if it's essential for the conservation of the species. So step one, they would look at identify the areas for consideration for habitat that is considered critical habitat, and then which meets the definitions of either occupied or unoccupied. Step two is, unlike with the listing process, for critical habitat, the agencies must consider the economic and national security impacts of designating critical habitat. That is not the case for a listing decision. And then they can go through an exclusion analysis. The exclusion analysis, it's, the agency may exclude, so it's discretionary. The most recent case addressing critical habitat and sort of tackling some of the difficult issues, particularly in the context of unoccupied habitat, is the dusky gopher frog Weyerhaeuser case. And if I will sort of, in full disclosure, I was the trial attorney for the case at the district court level. So this is a case that's near and dear to my heart. But I'm going to go through some of the points which bring up some interesting issues about critical habitat, whether it's meaningful, whether or not the process or the way the statute is drafted really gets at the needs of the species. But before I forget, I will note that designation of critical habitat, like with listing decisions, it does go through a rulemaking process. So of course there's opportunity for comment, and I think there's also a lot of debate about what it means. I think there's a lot of misinformation about what it means to have habitat designated as critical, land designated as critical habitat, which I think comes up a bit in the dusky gopher frog case. Essentially, if you are a private landowner and you are not engaging in any activities that would trigger, that have a federal nexus or would trigger some sort of approval process from a federal agency, then basically you have no restrictions or obligations on your land, even if it is designated as critical habitat, which again is an issue that comes up in Weyerhaeuser. If you are engaging in an activity that has a federal nexus, or you might need a permit from the Corps, or you are getting the, federal agency is funding your activity in some way, then you may require you to go through a consultation process, which Charmaine will discuss. So in the case of the dusky gopher frog, we have a very endangered species, this very picky frog that requires ephemeral ponds, which can only be filled for like a certain number of days out of the year, or else it might allow certain predators to live in the ponds and therefore eat the tadpoles, or the eggs. And so it has to be an ephemeral pond, and the ephemeral pond needs to be next to a very specific kind of forest, which basically has been utterly destroyed in the South. I think 98%, at least at the time, 98% of the kind of forest that this frog needs had been destroyed. So very picky frog with very picky requirements. And so it's not a surprise that the frog was down to 100 individuals in the wild. They're all around essentially one pond. And so, of course, the species listed as endangered, and the agency, after a lawsuit, goes through this process of designating critical habitat. They come up with a proposal. This frog is in Mississippi around this pond. They know they need more habitat than just this one pond. And so they identify some areas in Mississippi to designate. And so they go through this rulemaking process. and issue a proposed rule for the designation of habitat, and people respond, and experts and scientists respond, and the scientists uniformly say this isn't nearly enough habitat. One catastrophic event in the area, a weather event or something, could wipe out this frog. You have to look more broadly. Several of them suggested looking throughout the range, the historic range of the species, which had previously been in Alabama and Louisiana. So they look at all three of these states, and actually one of the experts, one of the researchers, had been on this private property in Louisiana, which was being used as a timber farm, basically. And they've been given permission to go on this property, and lo and behold, there are basically 5 pristine, like basically the best looking ponds, ephemeral ponds that you can find, and they're close enough together that it actually would allow for a meta population. So it's amazing. But the forested habitat next to it, because it's being used as a farm, it's not, you couldn't just drop a frog in and it would be like, yes, this is paradise, this is perfect. But if there were that much habitat available for this frog that was perfect, the frog probably wouldn't be down to 100 frogs. So the agency responds, and it adds a unit in Louisiana where the frog hasn't been seen since the 60s. The frog could not hop from Mississippi to Louisiana to get to these ponds, but maybe down the road, if there's some negotiations or something, maybe the frogs could be there and these ponds would be fantastic. All of the rest of the areas that they looked at, the ponds were gone and filled up, and there were no options. So in any event, as much to, I think, everyone's surprise, we actually win at the district court level and in the Fifth Circuit. But the case goes up to the Supreme Court, and the claims have sort of changed a little bit by the time they get to the Supreme Court. But the main claim is that in order to designate critical habitat, it has to constitute habitat first. And there's some, I think the main argument is, well, if this isn't exactly the way it, like, if not all components are essentially at the level of, like, they're ready to go for the species, they meet all of the species needs right now, then it doesn't constitute habitat. So essentially the Supreme Court ends up kind of punting a bit by saying, you know what, the lower courts didn't actually make a determination because they said that the area doesn't have to be habitable. And we can debate about whether or not being habitable is the same as whether or not it constitutes habitat. But they said the courts decided it didn't need to be habitable, and so therefore we're going to remand so that the lower courts can decide what constitutes habitat. Ultimately, the agency, Fish, ended up settling with the landowners and agreed to exclude Unit 1. So at least in litigation, what constitutes habitat was not decided. The decision also said the agency's decision whether or not to exclude an area that is reviewable by court, and so that also was remanded. But that was a key, I think, sort of a key decision on in terms of what the process moving forward would look like for habitat. Very briefly, notice was recently, the Trump administration recently issued a proposed rescission of the harm definition, which Charmaine may talk about. because it's in the context of the take prohibition, but it pertains to sort of largely targeting this issue of whether or not habitat, the destruction of habitat, constitutes a take, which, given sort of the listing, given our discussion on Section 4 about the importance that habitat plays for the future of species and whether or not they are endangered or whether or not they're going to become recovered, I think is sort of a critical issue that will be I think everybody will be paying attention to in the ESA context. So I'll hand it over to Charmaine now to continue with Section 7.
Thank you, Mary.
There we go. Hi, everyone. Thanks so much for being here. I am going to continue the ESA portion with a discussion of Section 7, interagency cooperation and consultation. I'm also mindful that I want to save some time for questions, so I'm going to do the best I can. Bear with me. So Section 7 of the ESA requires federal agencies and non-federal parties receiving federal funding or permits to ensure that their actions are not likely to jeopardize the continued existence of listed species or adversely modify critical habitat. And that process happens in multiple steps, and it's called consultation. In the broadest terms, consultation refers to a requirement that an agency has to consult with the expert wildlife agencies, namely the U.S. Fish and Wildlife Service, the National Marine Fisheries Service, before doing anything that might harm listed species. And this is a powerful provision because theoretically, consultation is triggered whenever an action may affect listed species or their critical habitat, and that's a pretty low bar. So there are many examples of actions that can trigger ESA consultation. The U.S. Forest Service is proposing a logging project that might require consultation. The U.S. Army Corps of Engineers wants to build a dam. EPA is proposing to approve a new pesticide for commercial use. All of those things could require ESA Section 7 consultation. So one of the first steps in the consultation process is the action agency figures out whether there are listed species in the action area. If so, they need to prepare a biological assessment. If in that biological assessment, the action agency determines that the project is not likely to adversely affect listed species and the services concur in that determination, then we're done. Nothing else required. And that process is referred to as informal consultation. More broadly, informal consultation is just kind of like the back and forth communications between the action agency and the expert wildlife agencies regarding project impacts to listed species. But if in the biological assessment, the action agency determines that there are likely adverse effects to listed species, then formal consultation is required. I pulled this flow chart from the Congressional Research Service. I like it, but I'm giving them credit. It's a good flow chart. So formal consultation is a lengthier process compared to informal consultation. And informal consultation, the services prepare their own analysis of project impacts on listed species, basically independent of the action agency's analysis in that BA. And formal consultation culminates in an extensive document called a biological opinion. So I'm going to call those BIOPs for short. BIOPs can basically go in one of two directions. Either the services analyze the action and determine that it will not jeopardize listed species or adversely modify critical habitat, then it's a no jeopardy BIOP. In that instance, the services just need to include an incidental take statement in the BIOP that authorizes limited take of listed species that are incidental to the project action. So essentially, it's just ensuring that the action agency won't face ESA Section 9 liability for the previously disclosed and analyzed impacts of their project on listed species. Or the services could analyze an action and determine that it will jeopardize listed species or adversely modify critical habitat, in which case the services must suggest reasonable and prudent alternatives to the action, along with the incidental take statement so that harm to species is minimized. It's worth noting that most Section 7 consultations result in no jeopardy opinions, and nearly all the rest identify these reasonable and prudent alternatives so that the originally proposed action is permitted to go forward. It is pretty rare that the services make a no jeopardy finding, that they make a jeopardy finding, but then also determine there's no reasonable alternatives to the action. And kind of related to that, there's some myths I think that are worth correcting about ESA Section 7. There's a study that came out 10 years ago that showed over a 7-year period, there were roughly 80,000 informal consultations and only 6,000 formal consultations. And informal consultations took an average of 13 days to complete, while formal consultations took an average of 62 days. So that's not that long, despite what you may have heard. I want to talk about an example of an ESA Section 7 case. And this is about the Florida manatee. So 5 years ago began a multi-year mass mortality event for manatees in Florida. And the context is that excess nitrogen and phosphorus was getting into Florida's waterways, and it was from septic tanks, fertilizer runoff, agricultural runoff. This excess nutrient pollution created harmful algal blooms, which blocked sunlight from getting to seagrass. And it's actually pictured in this photo. The seagrass is the manatee's main source of forage. So without sunlight, the seagrass died, the manatees lost their main source of forage, and the manatees in turn starved to death. This culminated in over 1,200 manatees lost in a 17-month period within the last 5 years. So our theory of the case was that EPA had approved Florida's water quality regulations for nitrogen and phosphorus, but those regulations were not stringent enough, as evidenced by the fact that manatees were dying from nitrogen and phosphorus pollution en masse. So the previous slide laid out the process for consultation under the ESA in the first instance, but sometimes reinitiation of consultation is also required. For example, when there's new information that shows that the action may affect listed species in a manner or to an extent not previously considered. So on behalf of several conservation groups, we sued EPA to reinitiate Section 7 consultation over its approval of Florida's water quality regulations for nitrogen and phosphorus on the theory that EPA and the services needed to work together to figure out whether or how to modify these underlying standards so that manatees would stop dying. Ultimately, the court disagreed with us that reinitiation of consultation was required, but our manatee work is not over. And sadly, this ecosystem is still in a very fragile state. Mary mentioned the God Squad. I'm going to briefly talk about it a little longer because this is about ESA Section 7. So as you've heard, Trump has invoked the God Squad in executive order. And again, God Squad refers to the Endangered Species Committee, which is empowered to effectively override adverse findings that flow from the consultation process. And as Mary mentioned, the committee consists of 7 cabinet-level officials who can vote that major economic factors outweigh ESA requirements. But it's worth noting that even to get to that vote of those 7 officials, good faith consultation has to have already occurred. alternatives have to have already been considered, buyouts have to have been issued. So the committee is not actually vested with power to bypass all of those requirements. Let's move now into the ESA Section 9 take prohibitions. Section 9 might be considered the teeth of the ESA, but it works in kind of an interesting way. So the text of the statute itself prohibits take of endangered species. And take, as you see here, is defined with this long list of verbs: harass, harm, pursue, hunt, shoot, long list of verbs. But take of threatened species works a little differently, and this implicates what's called the blanket 4D rule. So basically, a couple decades ago, Fish and Wildlife promulgated a regulation known as the blanket 4D rule, and that basically extended all the take prohibitions that apply to endangered species by statute to threatened species as well, unless there is a species-specific 4D rule. So historically, these 4D rules provided the same protections to threatened species as applied to endangered species, unless, again, there's a species-specific rule. In 2019, Fish and Wildlife modified the regulations to no longer employ the blanket 4D rule for threatened species, meaning there was going to be no de facto protections from take for threatened species, unless there was a species-specific rule. But then in 2024, the blanket 4D rule was reinstated. It's been challenged. You know, this is the pendulum swing that folks have been talking about. It may change again. Let's also take a moment to zero in on the meaning of two verbs within the take definition in Section 9, harm and harass. So harm is defined to include significant habitat modification or degradation where it actually kills or injures wildlife by significantly impairing essential behavioral patterns, including breeding, feeding, or sheltering. And that regulatory definition, I think, is the service's acknowledgement of the legislative history of the ESA and the scientific reality that Mary is talking about, that destroying species habitat constitutes real impairment of species' necessary life functions. You see this slide includes an ominous "for now." That's the harm definition, for now. That refers to the fact that back in April, the services proposed to rescind this regulatory definition so that harm would no longer be defined to include significant habitat modification. That regulatory definition of harm to include habitat degradation has been in place for 50 years. It was upheld by the Supreme Court 30 years ago. The proposed rule received over 150,000 comments in opposition to the rule rescission, so we're waiting to see how it's finalized. Also on this slide, harass. It's defined differently in the statute from harm, of course, and what's significant here is that there's an exception for captive animals that Mary will talk about. Under this exception, for example, vets and zoos following minimum standards of care will not be prosecuted for take under the ESA. Oh, ooh, nope. There. Okay, I want to talk briefly about an example of a Section 9 take case in the wildlife context. So back in 2021, the state of Idaho passed a law that authorized year-round wolf trapping on all private property and issuance of an unlimited number of wolf tags per person. And this was apparently part and parcel of the state's of Idaho's goal to kill up to 90% of their gray wolf population. But grizzly bears, which are listed as threatened under the ESA, were getting caught and killed in wolf snares and traps, and this constituted, prohibited take. So our colleagues brought litigation challenging the Idaho law. The court holding says there's ample evidence in the record, including from Idaho's own witnesses, that lawfully set wolf traps and snares are reasonably likely to take grizzly bears in Idaho. So the court enjoined that Idaho law. It's worth noting that Section 9 take cases are very labor and resource intensive. They often require significant evidentiary showings, so they're not brought that often. Kudos to my colleagues. I think now I'm going to pass it back to Mary for a moment to talk about take prohibitions in the captive context.
Thanks, Jeremy. So very quickly, as she mentioned, Section 9 cases are rarely brought, and in the federal government, even though I think probably the federal government and the Department of Justice is in the best position to bring those cases. They often don't for a number of reasons, but where they have actually pursued litigation recently is in the captive context. And so, one thing we didn't really get into is that the Endangered Species Act protects, by and large, protects both the captive and the wild individuals of a particular species. And the first, major case, the first case that the federal government ever brought under the Endangered Species Act as to captive animals was the one against the infamous Jeff Lowe of Tiger King fame. And basically, in that case, established a number of actions that constituted take via the harm and harass definitions. And those include everything from, failing to provide a nutritious diet to failing to provide adequate shelter, removing cubs prematurely, removing lemurs prematurely from their mothers. But it was a huge victory that has then been used in a number of other captive cases.
Great. Thanks, Mary. So I'm going to move on now, just I think I can finish out some of this in the next few minutes, to ESA Section 10. So I called Section 9 the teeth of the ESA, but Section 10 is important too because it reflects Congress's attempt to balance species conservation with other legitimate goals like land development. So Section 10 sets out exceptions to take. It says that take will be authorized if it is only incidental to and not the purpose of an activity that is otherwise lawful. So say you want to develop land on listed species habitat, you can do so if you apply for an incidental take permit. If you do apply for an incidental take permit, you also have to submit a habitat conservation plan that meets certain requirements. It has to specify the impact of the plan taking, the steps to minimize and mitigate those impacts, and the funding to take those steps, and alternatives you consider to the taking. I'll note that financial assurances is listed as a requirement in HCPs on this slide. What's meant by that? Basically, the permit applicant has to show that they'll ensure adequate funding for implementation measures so that they'll be successful. So, for example, an HCP might include the creation of a habitat preserve to offset destruction of habitat. The permit applicant has to show how they intend to fund the purchase of land for conservation easements in perpetuity. And again, briefly, I just want to highlight an example of the ITP HCP regime in a dynamic context. The golden cheek warbler is an endangered migratory songbird in Texas Hill Country. It's the only bird whose breeding range is exclusively within the state of Texas. Unfortunately, 95% of the warbler's habitat is on private land, and its habitat is right next to Austin and San Antonio, which have experienced significant population booms in recent years. So there's tremendous development pressure on warbler habitat. And that's kind of captured by the fact that the Fish and Wildlife Service database shows 177 HCPs and associated ITPs for the warbler. And a lot of those represent developers who want permission to destroy or degrade warbler habitat in exchange for certain assurances, like they won't cut down trees during the breeding season or they'll plant trees elsewhere. So, the prohibition against take in the ESA is forestalling extinction of the warbler. But even with the prohibition, the warbler lost 42% of its breeding habitat in the last 40 years, and those pressures are expected to rise. Ooh. Last slide. The Section 11 ESA citizen suit provision. This is a good place to end because this is a really important thing that the ESA has. Jonas mentioned that NEPA does not have a citizen suit provision. Citizen supervision means private parties can enforce the ESA. They don't have to wait for the government to enforce violations of the statute. So they can bring cases around failure to initiate Section 7 consultation, Section 9 take, Section 4 listing. This is a powerful thing. Gotta love the ESA. With that, I think I'm done. Thank you so much, everyone, for listening.
Well, thank you all. We have just a little bit of time for questions. I've called a few from our Q&A box. Jonas, first question goes to you. Do you anticipate that public participation in the context either of an EIS or of an EA are in jeopardy now that the CEQ rules are going to be abrogated? The questioner believes that that's only a requirement of CEQ's rules.
Right. I mean, we'll have to wait and see what CEQ comes up with their guidance and what each agency has in terms of public participation. I mean, you've seen already drastically shortened public participation timelines. I mean, off the top of my head, I believe there was a 5-day public comment period, which spanned over a weekend for a small kind of a mining related project. There's kind of condensed 14 to 30-day public comment periods. I mean, there's still going to be opportunities for public involvement. There's some that maybe there's emergencies that would adequately justify kind of shortening that time frame. But certainly, I think we're going to be seeing kind of a condensed or a shortened opportunity for public comment. So just for folks to be aware of and be a little more vigilant on those Federal Register notices of intent.
Jarmeen, you get the next question. So in the manatee context, would there be take liability for anybody associated with those pollution overages?
I'm so happy you asked. In fact, a federal district
Just an
judge.
easy question, the low ball, right?
A federal district judge has just ruled that the Florida Department of Environmental Protection's failure to adequately regulate wastewater discharges constituted a violation of Section 9. So that was a powerful holding that we were excited about.
That is an interesting development. Mary, you get the next question. So as the Trump administration moves forward trying to repeal the regulatory definition of harm, what sort of consequences can we anticipate for the Endangered Species Act?
So for those of you who, as I mentioned earlier, the focus of the rescission of the harm definition is on habitat modification and destruction, which, I think it's sort of an odd justification or an odd move to make in the sense that a species can be listed for the destruction of habitat based on like impacts of destruction of habitat, but then those continued the continued destruction of habitat and modification of habitat doesn't then constitute a take that they can be protected from. So it's sort of a curious move, although I think we can probably guess why they're doing it. I think it potentially is pretty harmful given that I would say as I mentioned before, like one of the main sort of drivers of like reduction in species populations is the destruction of habitat. So if habitat, isn't factored in, if you're not considering it, if there's no take, then anytime there's, incidental take decisions wouldn't be, there wouldn't be any potentially any room to consider impacts to habitat. So I think it remains to be seen how, how they apply that. But if the impacts to habitat are not considered take, I think it's pretty detrimental to the species that are listed because of impacts to habitat.
Jonas, you get the next question. So this questioner wondered, what sort of information do agencies generally try to collect in their NEPA processes from public comment?
So it's a full array of potential impacts. It could be concerns from noise related activities for the project. It could be increased traffic. It could be, recreational impacts. Maybe there's a significant local trail or other kinds of outdoor recreational activities that could be affected. All of these kind of meaningful impacts that may not be right at the forefront of the federal action agency. So all of that information would be helpful.
Thank you. Charmaine, you get this one, and this one is way down in the weeds, but I have to admire the questioner's specificity. So you mentioned the repeal of the blanket 4D rule. Are you aware what happened to the species that lack their own 4D rule when the blanket 4D rule was repealed? Did the Fish and Wildlife Service go back and revisit those for specific treatment of them?
Oh, goodness. That actually might be a question for Mary. I actually haven't been following the blanket 4D rule machination so closely.
Oh.
And Mary, you're on mute.
Yes, that would be helpful. So if a species was listed as threatened before before the Trump administration changed walked back the blanket rule, they remain protected. So it didn't affect the species that were already listed, and then those that were listed following that reg, those received individualized species specific 4D rules. And then of course the rule went back into place in 2024. So I think it just affected those species that were listed as threatened in between those two regs.
Jonas, I have another question for you. Are you aware of any mechanisms to compel the selection of the environmentally preferred alternative?
Not under NEPA. So not under the NEPA analysis. Now there's other permits, like let's say we can take a 404 permit, which the Corps requires the it's the lead pun, and now I'm going to be put on the spot for the acronym, the least environmentally detrimental practical alternative. Maybe
I like
something along those lines.
I like it.
Maybe someone else can feed me the letters. So there's other kind of permits that may require a certain kind of agency action, but there is no obligation under NEPA. It's purely procedural and does not force outcomes.
So this one is probably for either Mary or Charmaine. Assuming a hostile administration would like to delist the polar bear, and I know this is a tendentious assumption, but assuming that's the case, one of the premises that was relied on heavily is the polar bear's inability to adapt quickly, being a sea ice obligate. If we're seeing polar bear adaptation at a rate faster than it was anticipated then, what do you think about that as a basis for delisting, supposing an administration were to try?
Okay. So I mean, I think the last time I checked, I think the polar bear populations are still decreasing. So I think there are other factors, right? That's not the only factor, is whether or not they can adapt, but I think we're finding that they actually can't. So I think it's going to require like the full picture to take a look at, whether or not they should remain listed. I would be pretty surprised if even with an administration, even with the current administration, I would still be pretty surprised by a move to delist the polar bear.
Thank you. Well, I think that might be all the time we have, panelists. Thank you so much for some really detailed and careful analysis of these two statutes.
Thank you,
Yes.
Jameson. This has been great, and thank you, ELI. Thanks, everyone.
Yes, thank you all so much. I want to give a huge thank you to our fabulous speakers today. Thank you to Jameson for moderating, and to Jonas, Mary, and Charmaine for your insightful presentations. We so appreciate your time and energy. You fit so much great content into such a short period of time. Thank you as well to our audience for tuning in. As we said at the beginning of the webinar, this program was recorded, and the recording will be posted to ELI's website and YouTube page within a few business days. This was only the second program of our summer school series this year. We have so many more sessions in store for you each Tuesday throughout June and July. We'll see you next week, either online or in person at ELI's office for our Clean Air Act session. The week after that, we will be back online for our energy law session. You can find out more information about summer school, including the registration links for all the upcoming sessions at eli.org. We've also dropped the link in the chat. And lastly, programs like these are made possible with the support of ELI members. ELI membership is free for students, so we also encourage our summer school attendees to check out membership. Members can attend exclusive member webinars. They also have access to our entire webinar archive, along with many other benefits. So please check that out at eli.org. And thank you all once again. We hope you have a wonderful day.
Thanks for having me.